Hello, ready to talk about contracts some more? Well, in this module, we are talking about three more elements of a contract. You remember last time we talked about what is a contract, and then we looked at the agreement portion, which is offer and acceptance. So we have five elements to be a valid enforceable contract. And remember, because a contract is a legally enforceable promise, that's our goal. We want this to be enforceable in case things go wrong. We want to be able to come to court and have the judge order that the other side comply with it or make some other reparations, money, damages to make up for the non-performance. Okay, so we have offer and acceptance, consideration, capacity of the parties, and legality. It has to be for legal purpose. Those are our five elements. The last three we're talking about now in this module and learning about them. So let's look at consideration. I think of consideration as the glue that holds the contract together. It's really the guts of the contract in the sense that people can promise all sorts of things, but the question is it real? Is there really something you're getting in return for this promise? So when we look at consideration, we actually look to see what is exchanged between the parties. So we take party A and say, okay, you're getting this and you're losing this. You're party B gaining this and losing this. Often it's something very simple like money and goods. One party gives up money, gets the goods. The other party gives up the goods and gets the money. Think of it that way. And there has to be something exchanged, but it doesn't have to be something like that. It could be that you're providing services for money. It could be that you're agreeing to not do something that you otherwise had the ability to do. For instance, if you sign a severance agreement when you leave a job, that's enforceable. The consideration is you're agreeing in exchange for this lump sum money that you're receiving, you're giving up something. Read those contracts well because you are giving up something. And the typical thing is you're giving up the right to sue, which ordinarily you would have been able to sue for breach of contract, maybe employment discrimination. It could be based on your age or your gender or your race. And so there'll be a list of things and it'll include them and say others as well, right? You're giving up the right to sue. And in exchange, you're receiving money. Now that's considered valid consideration. We don't go as a judge into your head to see, is it really worth it? Would I advise you to do that? We don't do that. And the other thing we don't do is look to see if the value that you're receiving is worth the money. So you might have seen this sort of situation might have happened with you where a family member gave you a car, but I'm putting air quotes, sold you a car. And you say, well, wait, what's the difference? Did you notice in those transactions that at least $1 was exchanged? And you might say, well, the car is worth more than $1, but my parents sold it to me for $1. Why is that? And the reason is that if they had given it to you, it would have been a gift subject to gift tax. And they want this to be a sale. And then it goes in the back of your title as a sale, right? As a transfer of title. And so there has to be at least $1 exchanged. There's an expression for this, and that is that mutuality of consideration is not necessary or adequate. So we don't look at the adequacy of consideration is often how I've heard it said. In other words, we don't look to see, well, was this a good deal for you mutually? We don't look to see, well, was it really adequate, the amount of money you received? That's really the whole idea, as long as it's something. Now, conversely, what if you receive nothing at all? If you receive nothing at all, then this is not an enforceable contract. And often what happens is there's a modification of the contract. In other words, the original contract was fine, and now somebody renegotiates. I'll give you a good example in a minute. They add something, they change something, and you might say, well, can you do that? Well, you can if each party, so it's like a mini contract. If each party agrees to it, we've got offer and acceptance, but there still has to be consideration. There's got to be something that you received in exchange for that modification. So every modification has to have consideration. And so what might happen in that situation, for instance, is let's say the construction is going late and I'm building a room, I'm having that added on to my house. And then the contractor comes to me and says, well, look, I can get you that room in advance and even early, okay, but I'll need extra money for that. Well, if I were to think that's worth it to me, it's my own personal decision. I say, it's a nice space. I'd love to have a New Year's Eve party here. If you could have this ready for New Year's Eve, sure, I'd give you an extra $5,000. Well, that's perfectly fine because we negotiated offer and acceptance. And in exchange for me having the room done early, I am giving the extra money. Now, you might say, hey, that's not worth $5,000. Well, we're not going to go there, right? As I said, we don't look to see the wisdom of this. So we just make sure it's something. Conversely, what if the contractor came to me after I've already sent out my New Year's Eve invitations and it was supposed to be ready, the room, February 1st, and he comes to me and he says, we're running late. We've had a lot of problems with our workers and all of that. And, we ran into some rock when we were drilling for the foundation. And so, tell you what, I could still get it to you in time for your New Year's Eve party, but I'm going to have to get extra workers and get extra overtime costs, but I will do it for you as we planned. You could have this room ready on time, but for an extra $5,000. And I am in a bind because I already agreed. I already sent out the invitations. I already made these whole plans. So I say, okay, fine, sure. In that situation, I didn't get anything extra for that extra money. All I received was a promise to do what he already promised to do, which is have the room done at the contracted date, the original contract date. And so that is not considered consideration. That is not. And so I don't owe him that extra money. Now I've blown your minds away. I see it. Okay. Don't use this to ill gains, folks. Okay. But you see, every promise has to have something to back it up. Otherwise, we call it what we call an illusory promise. ILLUSORY. It looks like a promise for something, but it's really an illusion because you weren't getting anything that you weren't entitled to get already. Anyway, you'll learn about that. That's consideration. You'll look at the details in the book and examples, hypotheticals, and you'll get a good sense of why we need to have some kind of consideration. Now, the next element we're going to look at is going to be capacity of the parties. And simply put, in order to have a meeting of the minds, you have to have a mind to meet. So if the person has a mental incapacity and they don't understand the contract, that wasn't a valid contract at all. If the person is a minor, they're underage, we say as a matter of law, they lack capacity to contract. And that's why, folks, you've had people co-sign for you, like your parents, when it was maybe a housing contract, right, with the university. And if you were under 18, they probably had you co-sign anyway for that because it had your parents in as maybe a backup because they're thinking, oh, well, you don't have the assets to support it. Same would be true, if you were getting a loan or something else. But the key is if you're under 18, then you can basically, I don't want to say renege, but you can get out of the contract because it lacked capacity. And therefore, you can get back. It's not a go for your goods for free. You do have to give back the consideration. So basically, you undo the deal. You have that CD collection and you're under 18, basically the merchant might have taken advantage of you by selling it to you, that Beatles collection for $500. The thought is we're going to protect minors by allowing them, because they really don't have, as a matter of law, even if they're very, very smart, we're going to protect that person from being taken advantage of and said you can undo this transaction and get your money back, give back the CDs, of course. Okay. So that would be an example. And there's certain things that we in the law say you lack capacity, but we're going to make an exception and say it is a valid contract. And that's because we're, again, trying to protect the minor. That's the doctrine of necessaries, where we say this minor needs this. It's usually, and every state defines it differently, but typically it's going to be something like food, drugs, medicine, shelter, and in some cases, education. These are considered necessaries. And in those situations, the minor is bound to the contract. And we do this because we think the merchant may not give you those things, sell you those things, knowing that you're a minor and you can get your money back. And so we've protected the minor by making those things binding. If you think of it that way, I think it'll be easier to understand. And the other kind of incapacity that you're going to see when you start going through the module, if somebody was temporarily incapacitated due to alcohol or drug use, or perhaps stress, anxiety in very extreme situations. And that would be a way for somebody to get out of the contract. But again, it's not a automatic. You would have to prove that the person didn't understand the nature of the contract and did not voluntarily enter into it. And that's, a question of fact based on all of the circumstances. And it's going to be a jury question like anything else to see if this person should be bound to the contract. And then the last element that we have is legality. Now, I mentioned it before, and I told you the contract has to be for a legal purpose. And it was easy to see with a drug transaction. Of course, the judge is not wanting to get involved in this and going to enforce a contract if it's for an illegal purpose. Well, in that example, it was simple because the subject matter of the contract was illegal. But what if there's something else, like a term that's not legal, or we look at legality much more broadly, something that's against public policy? In that situation, we're going to allow the judge, when enforcing or interpreting the contract, to cut out the illegal term. We call that the doctrine of severability, because it may be like an interest rate, let's say, that's higher than that allowed by law. Well, does that mean the whole credit card bill gets thrown out, that this contract is not valid? Well, if you could save the contract, the judge will. So it's very reasonable and logical to say, okay, well, you still have to pay the $5,000 that was on this credit card bill, but the interest rate is higher than that allowed by law. We call that a usurious, U-S-U-R-Y, usury interest rate. And the judge certainly won't enforce that. And the judge will instead substitute a reasonable interest rate. And that would be a way to, if you think of it, save the contract. And it's called the doctrine of severability. So look at a contract more broadly. One thing I want to tell you before we go any further in contracts is read your contract. Very, very super important. You can never come to the judge and say, I didn't read the contract, so I didn't really agree to it. That will never fly in court because we're always thinking 2 steps ahead. We want people to be, I'd say, sophisticated citizens. At the very least, we want you to be responsible. And so we're not going to let people out of the contract just because they didn't read it. And in fact, we want you to have the incentive to read it. But you could say, Judge, if you were to enforce this contract, it would be against public policy. There's something in here that's so fundamentally unfair. And I didn't have a choice in the matter. I had to agree to it. And on that basis, you could overturn, I'll say. I was going to say, get out of, but let's try to use the right legal terms for it so you can get used to talking the talk and thinking this way. That would be a way to get out of a contract. You could say, and here's another legal word for it, that the contract is unconscionable. Isn't that a great word? Unconscionable. And that means that you didn't have equal bargaining power. You had no choice. It's a very hard argument to make because most times people do have some sort of choice. Let's say it's a really bad installment contract at Best Buy for a TV. Well, sure, you couldn't negotiate because it's a big company and you couldn't sit there and cross out the terms on the contract. But you could have walked away and bought that TV somewhere else. Or maybe you could have gone without the TV if you couldn't afford it. So it's going to be hard to make the argument of unconscionability with something that really is maybe unfair, but not horrendous and against public policy. You just try the argument, more likely to be able to at least try it than, Judge, I didn't read the contract. I didn't know that was in there. That will not fly, baby. I'm giving you the tools that will enable you to succeed when it comes to your contracts in the future. I hope you enjoyed this, and I hope you enjoy this module and learn much more to come.